Hey everyone, Harry here to talk about Trump's filing in the upcoming trial, still scheduled for March 25th, though he's trying to delay it, in the New York courts, where Trump is charged with a scheme to keep his hush money payments to Stormy Daniels from the electorate. All right, this is about advice of counsel. He's tried this gambit before, and basically he just doesn't qualify. And in this case, anyway, he's not trying to assert otherwise, but he is trying to get away with stuff. Okay, we've talked about it, but advice of counsel, you can't just get up there and say, my lawyer told me this or that, because the immediate questions is, tell us everything your lawyer told you. Oh, well, there's attorney-client privilege. So no, you must waive attorney-client privilege. And not only that, you've got to give all the advice that all the lawyers gave you. And then you have to show you really did believe that a lawyer who told you this was okay, you really did believe that it was okay and went forward, because what the advice of counsel defense really is, it's kind of a confusing misnomer. It really goes to your not having the requisite criminal intent. If a lawyer who you trust sits down and tells you, here's the deal, and you believe it, and then you do the act, you don't have the mental intent. But to show it, you need to play an open hand about everything, not just this lawyer, but other lawyers told you. Some of this may well come up at the January 6th trial, where lawyer after lawyer told him, there's no basis for doing what you're doing. And he kept shopping until he would find someone with a bar degree, maybe, to tell him what he wanted to know. That's not an advice of counsel defense, because or it's not a valid one. He would have to lay out all the information he got to the contrary. Okay. The actual filing in the case going forward in New York is Trump saying, I am not relying on an advice of counsel defense, and therefore I don't have to do all these things that make it onerous and deter defendants from relying on one. In particular, he doesn't have to waive attorney-client privilege and reveal everything that the attorney said. So the, top line is no advice of counsel defense being offered in the New York trial, scheduled to go on March 25th, and that probably will go there or shortly thereafter. But in a very sort of coy and unclear way, he says, I nevertheless will rely on the presence of lawyers at certain places to suggest that, there were lawyers there, so I didn't really have the requisite intent. He uses the word intent. And that is a patent effort, and it's going to lead to tussles at trial, a patent effort to eat his cake and have it too, because that the whole point is what your intent was, and you can't just say, oh, well, this and that lawyer was there, so, and therefore argue to the jury, I must have believed them. You have to proffer the exact advice you were given and evidence that you actually believed it. By the way, I think he would have to do that by taking the stand. See Littman axiom number 1 that still stands until disproven, which is he won't testify. So he's got no advice of counsel defense, but from this filing, we can expect a trial that he's going to make efforts in his evidence to suggest lawyers were there and that it affected him, and that will prompt immediate objections and brouhahas with the prosecution, which will say he doesn't have an advice of counsel defense here. It's just irrelevant that this or that lawyer was there. By the way, taking a step back, it really is irrelevant. The lawyer in question here, Michael Cohen, is the main one. I don't know what other lawyer he'd be talking about, but he's testifying against him, and it's clear he didn't give him, advice that Trump could in good faith have relied on. But in any event, he may try to just sneak in insinuations, and that's what an advice of counsel defense, the law around it, shows. You don't sneak in insinuations. You make the whole showing, you play an open hand, and then you can argue it to the jury. But you can't do it in half measures, and that's precisely what it looks like to me Trump is going to be trying to do. And that will really engender scuffles at trial. And Merchant seems to me to be a pretty tough trial judge, and he's likely to shut it down. But we're talking about just those situations where you're in front of a jury, you ask, and were there other lawyers there? Objection, Your Honor, but the jury has already heard it. So it gets kind of dangerous in terms of its potential prejudicial impact toward the jury. So it's possible that you'll find Merchant responding to this little filing by Trump by trying to lay down the law and make very clear lines in advance saying you just can't mention X, Y, or Z. It's either that or try to deal with it as Trump tries to sort of sneak things in during the trial, cross-examination, prosecution witnesses, and the like. Okay, so no advice of counsel defense, meaning no waiver of attorney-client privilege, and yet an effort to do the same improperly that, to me, augurs some real skirmishes at the upcoming trial. Talk to you later. Hi, everyone. Harry here with a really exciting announcement. Talking Feds is bringing our lively discussions with prominent national figures live to San Diego. Talking San Diego is a new series of conversations with some of the country's most interesting and bright minds from the worlds of politics, public policy, law, and more. Our first event is just around the corner. Join me for a conversation with Congressman Jamie Raskin on Monday, March 18th at 2 o'clock in downtown San Diego. You can click the description box below for more information on the event and the series and find out how to purchase tickets, which are going fast. I can't wait to have some of our most well-known friends of the podcast join me in person before a live audience. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.